Okay, we in session and calls number 330-276. Case is style of state of Texas versus Alasia Newshade Compton. How are you doing? All right, I have before me judge's explanation of rights to defendants without an attorney, and also have an affidavit of indigence. Do you recognize these two documents? Yes. Okay. And prior to signing these documents, did you read the documents? Okay. I'm gonna give you an opportunity to go over these documents. But she can have a seat and just let her read the documents. You can just go take your seat. Yeah. Oh, you read them? Okay, that's what I asked. Did you read the documents? No. Now, before you, now, is this your signature on judge's explanation of defendant's right on the line that says defendant, and are these your initials on the line stating that you want to apply for court-appointed attorney? Also, I have here affidavit of indigence. Do you recognize this document? And on page 2 of the same document, is that your signature on the line that's titled defendant? Now, prior to signing the initial in this document, did you read the document? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, all right. Now, for purposes of Article 1.24 of the Texas Code of Criminal Procedure, you're entitled to all trials and hearings should be public. However, in the interest that the court is going to be disclosing some non-public information, the court is going to close this session of the hearing. Well, now, what the court is saying, that you have a right to have this trial or this hearing to be aired publicly, meaning that on Zoom, we on YouTube. However, I'm getting ready to ask you some questions about your finances, and pursuant to Lilly versus State, 365 Southwest 3rd, 321, it says that the right to a public trial is not absolute and may be outweighed by other competing rights of interest, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Now, the information that I will be asking you is your personal information, meaning that it's not public. Do you request that the court close this proceeding to the public so that we can ask you those questions? That's right, you want it private. All right, so the court finds that the defendant seeking to close the hearing must have advanced an overriding interest that is likely to be prejudiced to her, and that it will be disclosure of her financial information, and the closure must be no broader than necessary to protect the interest, and the trial court have considered reasonable alternatives, and the court makes a finding of that adequate that supports the closure. So at this time, this hearing is going to be closed to the public. Mr. Bailiff, we're going to ask that